Good morning, everyone. Today we are going to continue what we have doing in the last week before the recession. We are going to talk about the administrative sanctions which can be imposed on the defaulting party. In the last lecture, we have discussed the financial sanctions. We mean by that the sanctions which require the payment of money. We have talked about compensation or damages. We have talked about the payment of the late performance fines. We have talked about the confiscation of the provisional and the final security deposit. Today, we are going to discuss a different kind of sanctions. Sanctions which are aimed to perform the specific obligations of the contracting with the government. The administrative authority objective is to maintain the regular functions of the public services. In case the contractor or supplier failed to implement his obligations and commit a serious mistake, the administrative authority, if it wants to use the civil law rules, it will not enable it to get what it wants very quickly. It needs a decision from the judge. The contracting party, the defaulting contracting party, may refuse to implement its obligation by using the defense of non-performance, الدفع بعدم التنفيذ. So the rules of administrative law, the rules of administrative contracts provide the administrative authority with the power to implement the contract against the cause of the defaulting party at his own expense, charge him all expenses by its unilateral will, by a decision which is taken by it. There is no need to go to court. There is no need to wait for discussion with him, but immediately it will issue a unilateral order, will be informed by it through the express mail, telling him that we have decided to withdraw the contract from you and implement it at your own expense because you have committed a serious mistake. Now, the legal nature of this sanction, it is linked to the special characteristics of administrative contract. The administrative authority is under duty to conclude the agreements with the defaulting parties, with any party at any time, to maintain the regular functioning of the public services. So the administrative authority can do that at any time at its own discretion. Now, the question is, what about the rights of the defaulting party during the implementation of the contract? Before we talk about the conditions and the legal effects, we are going to make an important statement. The defaulting party has rights. The defaulting party is a part of the contract. Withdrawing the contract doesn't mean the termination of the contract. He is still the party. He is required to ask the administrative authority to he is required to ask the administrative authority to deduct the extra charges, the unreasonable charges which have been imposed against him. Now, what are the conditions to impose the withdrawal of the contract from the defaulting party? Under the law, the court decisions, there are two basic elements, two basic requirements to impose this sanction. First, the defaulting party must commit a serious mistake. Second, he must be formally summoned, notified to correct the situation. Otherwise, he will be sanctioned. If we start with the first requirement, the defaulting party must commit a serious mistake. There is forms of serious mistakes which can be imposed by the defaulting party. In French law, they said that the refusal to implement the executive orders from the engineer representing the government is a serious mistake. But when we go to the Egyptian law, we will find the last law of governmental contracting and the present law, new law, 182 of 2018, have referred to some serious mistakes which can be taken or committed by the defaulting party. If we read Article 50 of the new law, you will find reference to such serious mistakes indeed, such as committing a fraud and concluding the contract, manipulation, unfair practices, conspiracy, corruption. All of these mistakes are serious mistakes. Committing any one of them will give the reason for the administrative authority to impose this sanction, to withdraw the contract and implement it at the expense of the defaulting party by giving it to another person to implement it and let the defaulting party bear all the extra costs. Notice that the simple mistakes is not enough to impose this sanction. Just the delay in implementing the contract a few days doesn't give the administrative authority the power to withdraw the contract. As the case indicated in the book, it said that just the delay in implementation of the contracts, 5 days, doesn't require imposing this sanction. It is enough to impose the late performance fines in this case. Now, the second requirement to impose the withdrawal of the contract from the defaulting party is actually, it is important requirement. It is required for the validity of all sanctions which can be imposed by the administrative authority. It is the formal notification, al-i'dhar, notification of the defaulting party by the administrative authority that he is at default and he must correct the situation in a specific time. In the old law, it used to be 15 days. If he doesn't do that, the administrative authority will be excused to impose the sanction and to give the contract to another contractor to implement it. Now, are there any excuses from requiring this summons? The answer is yes. The civil law, which contains the general rule of contract, has said there are some cases under which the defaulting party can be excused from being summoned by the government. What are these cases? The most important of it is a formal declaration by the defaulting party himself that he is not going to implement the contract for one reason or another, or the case of the force majeure, or the case of impossibility to implement the contract. So, again, the requirement to impose the sanction is notifying the defaulting party he is in default unless the law or even the agreement provided there is no need to do that. One example is included in the new law of 2018, which is the non-payment of the person who won the contract to pay the final security deposit within 10 days from his notification. He is the winner. If he doesn't do that, the administrative authority, without any notification to him, any notification whatsoever, it can withdraw the contract from him and to give it to another person, another contractor to implement it. Now, it's time to talk about the legal effects of the execution at the expense of the defaulting party. What are the legal consequences which will be produced in case the administrative authority imposes such sanctions? There are two kinds of legal effects. First, the legal effects which talks about the powers and the rights of administrative authority. Second, the legal effects which talks about the rights of the defaulting party who is under the sanction. First, for the administrative authority, what are the rights of the administrative authority under the law and the case law in Egypt? First, preventing the contracting from removing any part of equipment and the materials and the goods in the work site, and to retain them until the completion of the contract to secure its rights. It has the right to sell any of the items existing in the work site. It also has the power to deduct the money it has lost, to deduct the late performance fines, and any other sums of money it is due for it from the money due to the defaulting party with it, with the contracting administrative authority, or with any other administrative authority in Egypt. And if it is not sufficient to cover the losses of the administrative authority, it can use its powers and privileges, including the direct execution, امتياز أو حق التنفيذ المباشر على أموال المدين. In addition to these legal consequences provided for in the law, there are some legal consequences which we can find it in court decisions. First, there is no payment for what have been delivered to the administrative authority. The administrative authority will stop the payment of any money due for the defaulting party because of his failure to implement the contract. Second, it has the power to use all the materials, all the machines, all cement, iron, everything included in the work site to implement the contract at the expense of the defaulting party. More than this, if the administrative authority is able, when it is implementing the contract at the expense of the defaulting party, if she is able to implement the contract with less money than required to be paid to the defaulting party, the surplus النفقات اللي هي استطاعت أنها تخفضها will be the right of the administrative authority. This the most important right of the administrative authority when it used the sanction of implementing the contract at the defaulting party. Now, what about the rights of the defaulting party itself? Is he powerless? The answer is no. He has the rights under the court decisions. He has the right to ask the court not to pay the unreasonable extra charges. He has the right also to ask the court for implementing the rules of agency in the civil contract. That means the administrative authority is in the position of an agent في مركز الوكيل who must do all of his best according to the ordinary person test. يجب أن يقوم بكل ما يجب عليه وفقا لمعيار المقاول العادي أو المهندس العادي. And finally, the administrative authority can be asked by the defaulting party to dissolve the contract through the court decision. That means the defaulting party may ask for the invalidation of the contract. He also has the power during the implementation of the contract at his cost to ask the court to review the decision to take the contract from him as abusive, violative to law, includes one of the defects of the administrative orders according to the Egyptian Council of State decisions. Now, we are going to talk about the last sanction, administrative sanction, which can be imposed by the administrative authority against the defaulting party. It is the dissolution of the contract. The most serious sanction can be imposed by the administrative authority. Why? Because it leads to considering the contract as non-existent retroactively إلغاء العقد بأثر رجعي للماضي. The administrative authority doesn't use this serious sanction, this grave sanction, unless the defaulting party has committed a serious and grave mistake, as we will see when we talk about the conditions. Again, the same principles we have indicated in the last case of implementing at the expense of the defaulting party, which is this sanction is inherently linked to the legal nature of administrative contract as a means to maintain the regular functioning of the public services, providing water, electricity, internet, or whatever the public services. How the dissolution of the contract can be materialized in reality? It is by unilateral will. Administrative order will be issued by the administrative authority according to its own discretion and will notify it by express mail by the Egyptian Post Authority as the new law of 2018 has provided. Now, what are the cases of administrative dissolution of the contract in the new law? This is serious sanction. How can be imposed? What are the cases of invalidating the contract? If we go to the law, the new law, we will find the article saying that the non-payment of the final security deposit within the period of 10 days of notifying the bid winner will give the administrative authority the power either to dissolve the contract or to implement it at the expense of the defaulting party. There is another case which is indicated in the important Article 50 and 51 of the new law of 2018. It is either the case of committing fraud or manipulation or corruption or conspiracy, or in case either bankruptcy or insolvency of the defaulting party. The law said also violation of any provision of the contract will provide the administrative authority with the power to rescind the contract, to invalidate of the contract. Now, what are the conditions of the administrative dissolutions? Is this dissolution can be imposed without any reservation by the administrative authority? The answer is no. The condition of imposing the sanction of dissolution or rescinding of the contract are the same condition of imposing the sanction of withdrawing the contract and implementing it at the expense of the defaulting party. What do we mean by that? We mean we need two basic conditions. First, the contracting party must commit a substantial mistake. The administrative authority can say he commits a substantial mistake, but of course its evaluation will be subject to judicial review. هيخضع للرقابة القضائية. We have given examples of the serious violation which will justify imposing this serious sanction in Article 50 and 51, and the executive regulation of the new law also included some examples of the serious mistakes committed by the defaulting party. Second, in addition to committing a serious mistake, the defaulting party must be formally summoned to correct his mistake within the reasonable period, must be notified that he is at default. He must correct the situation with a specific period of time. 15 days under the law and the regulation. If he doesn't do that, the administrative authority will be excused to withdraw the contract. Also, the notification, the summon and the notification is not required under the exception which are included in the civil law, which is if the defaulting party expressly said he is not going to implement the contract. Also, if implementing the contract by himself has become impossible, and also the case of force majeure القوة القاهرة. Now, what are the legal effects of the administrative dissolution of the contract? الآثار القانونية المترتبة على فسخ العقد الإداري. Under the Egyptian and the French also administrative law, we have two kinds of dissolution of the contract. Plain dissolution of the contract and the dissolution at the expense of the defaulting party. The first one is exactly like the dissolution of the civil contract and the commercial contract. Each party will return to the other party what has been paid. That means terminating the contract retroactively, and the administrative authority and the defaulting party will end up by returning of what has been benefited from the contract. What's important for us is to speak about the dissolution of the contract at the expense of the defaulting party. Here we have two sanctions combined together. The dissolution of the contract, terminating the original contract, and second, concluding a new contract and implementing it at the expense of the defaulting party, and the defaulting party will be charged by the payment of all costs of extra implementation. Now, this form of sanction exists only in French law, but what about the Egyptian law? Until the past law was terminated, there was a case of combination of the solution of the contract and the implementation it at the expense of the defaulting party. This is only the case of Article 120 in the old executive regulation, dealing with the case of the government contracts for selling real estates and the projects which do not enjoy juristic personality. Violation to the agreement leads to the application of the two sanctions together. Dissolution of the selling contract and from a new process to conclude the same contract for the selling of the real estates owned by the government. As a matter of fact, the Egyptian new law, the law of 182 of the public contracting of 2018, has invalidated these sanctions and included an explicit provision saying that these sanctions cannot be combined together, and this is included in Article 51 of the new law, explicitly prohibited the administrative body from using both sanctions, which means dissolution and implementation at the cost of the defaulting party for the same violation. For any reason, they cannot be combined together, either to use the dissolution of the contract by its own or to implement of the implementation at the cost of the defaulting party. إما الفسخ وإما التنفيذ على الحساب. And this will finish our class for today. Good luck. We'll see you again in the next lecture, and thank you for your patience.